I'm Frank Hartman with the Hartman Law Firm. I'm a practicing attorney in Charleston, South Carolina, specializing in auto accidents and personal injury. And today we're talking about how to represent yourself in your auto accident case and when the situation might be that you actually need to do so. Okay, the most significant thing that determines whether you should represent yourself, in my personal and professional opinion, is going to be the actual property damage that's associated with the auto accident. And what I mean by that is literally, what did your car look like when you got out of it and you walked away from the claim? If you're looking at your car and all you've got is some scrapes and some paint transfer, or maybe a slight dent in your bumper, the insurance, that's going to speak volumes to the insurance company, and in all likelihood the insurance company is probably going to consider that a misclaim, which is something that we talked about in an earlier video. The significance of that is they're going to put it in a little box, and they're going to say, we really just don't see how a significant injury could actually result from this particular auto accident. The reason being, your car doesn't look like it's actually been in an accident. If that's the case, it might be a situation in which you need to represent yourself. And it's actually, it's not that difficult to do so. It's just a matter of jumping through the hoops that the insurance company wants you to. What you need to do is you need to go out and you need to obtain all of the medical records and all of the medical bills that you incurred as a result of the auto accident. Make sure that you've got everything from the EMS to the emergency room, right up to any follow-up treatment. It's got to be from point A to point Z, and you've got to have all of it together with the corresponding itemized medical bills. You provide all of that to the insurance company, and they'll come up with your actual damages, which is going to be the equivalent of whatever your out-of-pocket medical expenses are, and then the value of your claim in large part will be based on that, plus something added for your pain and suffering. The issue with an auto collision in which the property damage is not that significant is that an insurance company in all likelihood is not going to pay that much on it. So if you involve an attorney and he has to take a third and the outcome really doesn't change all that much, all you're really doing is just taking money out of your own pocket. The other factor that you should consider is the actual treatment that you sought after the auto accident. If it's a situation where EMS came to the scene and you were transported to the emergency room ultimately just for a checkup, and they gave you your pain pills and your muscle relaxers, and then you went home and ultimately you really didn't have any discomfort, and more importantly you didn't seek any follow-up treatment, then in all likelihood you're probably not going to want to move forward, because the way an insurance company values your claim is, specifically with regard to EMS and emergency room bills, they pay those dollar for dollar. So if you've got an EMS bill of $300 and an emergency room bill of $1,000, your actual damages are $1,300. And since there's no active physical therapy or chiropractic that you sought, then the value of your claim is $1,300. And obviously they're going to put something on top of that for your incidental pain and suffering, but for the most part it's going to be very limited, simply because you just wanted to get yourself checked out to make sure that you were okay. And if you're okay, well then ultimately you didn't have much in the way of an injury, and quite honestly you just need to be reimbursed for your medical expenses for the purposes of being checked out, and you can go on with your life. If you decide you want to go ahead and represent yourself, and you've got your medical bills and the corresponding medical records, go ahead and send them into the insurance company and maybe put some sort of time demand on it, say 15 days from the date of this letter. It's important that you either fax or you email it, because the paperwork itself is what's creating the accountability, because they can promise you anything all day long on the telephone. It's important to create a paper trail. So once you've actually provided that to the insurance company, they will call you back with an offer based on the medical bills that you've submitted. Bear in mind, you don't have to accept that offer that there is a necessary negotiation there, okay? So whatever they offer, you don't necessarily have to take. You do, you make a counter demand. So say they offer $2,300 and, you want, I don't know, $4,000 for the purposes of this video. You say, well, no, I think my case is actually worth $4,000. There's going to be some wiggle room in there, and in all likelihood the adjuster is going to be willing to work with you, and you'll probably end up settling the case somewhere in between, splitting the baby, maybe $3,300 or something along those lines. And then you sign your release, you pay your medical bills, and whatever's left over, ultimately, that's your compensation for the inconvenience of the auto collision and the pain and suffering that you experienced as a result of it. I'm Frank Hartman, and today we talked about should you represent yourself in your auto accident case, and if so, how you should go about doing it. If you have any questions, I'd love to speak with you. I strongly encourage you to pick up the telephone and call me at 843-300-7600, or feel free to learn more about me and my firm at thehartmanlawfirm.com.